Trade creditors are generally pretty used to getting a hard time. If it isn't someone going bust owing us money, we've got a situation where someone's disputing an invoice, and if that's not the case and we get the money in our pockets, there's a liquidator looking at us asking for it back. If all of that isn't enough, the government, Commonwealth government, seems to like shifting the goalposts consistently and just making our regulatory, our life, day-to-day administrative life all that much harder. We've seen the issues that we've all just been through with the PPSA and how we've had to gear our businesses up for the PPSA. That went live about not quite a month ago, and now we've got to deal with the next headache, which is privacy law reform. As Terry mentioned earlier, our business, Results Legal, we're a specialist law firm. We focus on commercial disputes, debt recovery and insolvency, which may lead you to ask why are we spending the time on privacy law reform? Essentially, our focus as a business is on the trade credit space, trade credit clients. What we seek to do is to, if there's an area that's impacting trade credit clients from a legal perspective, we're focused on providing solutions to try and make our clients' lives easier. So an example of that in recent times, at PPSA, the obvious thing when PPSA was coming in as an opportunity to assist our clients, we saw that obviously recovery action and using the PPSA to go and collect goods and get them back, or to focus on the proceeds and use those mechanisms to put money in our clients' pockets. But at the time, and as we're getting across the regime, it became apparent that to do that and to actually help our clients save money in the long run, it was more important to get everything in place at the start and to get all of the ducks in a row. And hence we put a lot of time, energy and resources into helping our clients get their terms and conditions right, getting their internal processes right. When the privacy law reforms came about, it's a very similar situation. We see this as an opportunity where, look, the legislation is voluminous, it takes a long time to get through, and on the face of it, has a real potential to cause a massive headache for trade credit. So our team has set about to get across the legislation to try and make our clients in the trade credit industry essentially have an easier solution to be able to achieve the compliance that's necessary. We're focused on, and our team's put north of 100 hours into getting across privacy law reform to be able to develop a compliance package for our clients, just to make this whole process of ticking the boxes and getting regulatory compliance easier and more cost effective and less of a drain on administrative resources. So, you know, those experiences are essentially mainly what I've drawn on in pulling this presentation together for you this morning. It is a red tape nightmare, the privacy law reform. There's been obviously the Commonwealth Government and the Privacy Commissioner have made some fluffy statements about why all of this privacy reform is necessary, and I get that. At a conceptual level and an ideological level, I get why this privacy reform is necessary. This sceptic in me wonders though how much of an impact it really makes. The information that as trade creditors we're keeping, how much of that is really going to the altruistic purposes of us complying. I have some scepticism around it. However, it's here to stay. It comes in place on the 12th of March, and whether we like it or not, we do have to deal with it. So what I'm aiming to do this morning is to try and help cut through some of this red tape and complexity. I'm not going to cover everything about the privacy reforms, the APPs, the credit code. I couldn't do that this morning if I wanted to. You might have seen that the AICM ran a good series on this last year. It was a 2-day series. We've got about 45 minutes, so you're going to have to get the elevator pitch, but I am aiming to do it in a level where I'm talking about the key concepts, and what I'd ideally like is that we can all walk away this morning to have taken something away that we get how it applies and how it's likely to be relevant to our businesses, and to be able to start to work towards a game plan of being able to achieve compliance and not get ourselves into strife. The other thing to note that I'll touch on as well is that there are some real consequences involved in non-compliance with privacy reform, so it is something that we have to deal with whether we like it or not, unfortunately. So what I'm going to cover this morning in terms of the topics. One, I'll talk about how the reforms all fit together. There are a couple of distinct categories of reform and they do have an overlap. The two main areas in the reforms are the APPs, Australian Privacy Principles, and the credit reporting provisions, Part 3A in the Code. So I'll talk about the relationship between those two aspects. I'll talk about who must comply, who has to comply with each of the various areas of the reforms, what kind of information is caught by the reforms, because we have to remember this is all about information, the collection, the use, and the on-disclosure of information and the access to that information. I'll talk specifically about the APPs, I'll talk specifically about the credit reporting provisions, touch on consequences of non-compliance, and work towards just giving you an outline of some of what we consider to be the most effective ways to achieve compliance.